And position 4 will be logging on shortly to take up speed. On the compliance calendar, 20 COV 0000347, that case has been now crossed by the state. On case 20 CR 0023883E, the defendant will log on late to give us an update. And 22 CR 0061860 is a simple battery case. Mr. Corn, do you have an announcement for that case?
I don't believe that it's completed. It is a divergent case. I don't believe it's completed. He had signed on or tried to sign up, and they said they didn't have his registration information. It hadn't been forwarded. So I'm just looking for,
Just for a further reset,
if I could, Judge.
does the state object to giving Mr. Walker additional time to complete diversion?
No, Your Honor, I did speak with, PD, God on that one, and it is in diversion, so no objection.
Okay, can we reset maybe 2 months?
That should be fine, Judge.
Would you like to place it on a March 1st, a status calendar instead of?
That's fine. He can, will we know that he's there for compliance, so will that be no?
Yes.
Okay, that's fine. So we will reset him to the March 3rd. Status, Mr. Horn, and he can just indicate that he's there for compliance, or you can let us know that if that.
That would be fine, Judge.
Do you have any additional cases, Mr. Horn?
I don't, but I want to make sure I talk to him. So I'm going to hang around a bit more.
Hopefully he comes, all right.
Yeah, otherwise, I don't know why I'm here.
Okay.
Brief announcement.
Okay, great.
On position number 1, I did have a question about it. Is that date? It was April. Do we have a date yet?
Yes,
On position 1 on the motion, 419.
Okay.
And,
Yes.
One on.
yeah, 419.
On the compliance? Are you the Amber Holmes?
No, Mr. Bennett, on the motion.
Oh, Mr. Bennett. Okay, Mr. Bennett, your case has been reset. I believe there was a conflict entered.
Yes, ma'am.
So your case is gonna be reset to the 19th of April. You're free to go at this time.
Yes,
Yes, you may. Take care. Have a good day.
And then one more brief announcement on
Okay.
position number 3. I'm in touch with the officer. He's stuck in a little bit of traffic. He is on his way. He'll be here shortly. Just ask that we hold on.
All right. This will be the day that I'm supposed to read at my child's school this afternoon. Hopefully I'll still make it.
Ms. Waldorf. So yesterday, I was on the phone with, I was on email with Rosenberg and.
Oh, yeah.
No, it's not.
Oh, okay. So I don't have to tell him. He knows.
Oh, yeah.
Gotta get a temporary hip on it.
It's news. I'm just gonna use this with my power. It goes around my neck. He's got my face on him, so.
Kind of like a photo sign.
But, hello, yeah, it's back.
I'll use this time to read motions. I think, Mr. Birch, is Mr. Nash is the.
This is the attorney that can plea.
Ma'am.
Yes, that's me.
All right, Mr. Nash, are you able to hear me?
Yes, ma'am, I'm here.
Is your client online?
I have my client in my lobby. Should I get him, Your Honor?
Yes.
All right.
Oh, she good.
That's a good change.
Which case is this for, Judge?
It is position 4 on the motion calendar, I believe. Is that?
Yes, Your Honor.
All right.
Get in that picture right there. Slide this way.
Mine was just cut off at the bottom.
I'm sorry, Ms. Carter, what'd you say?
I just said my calendar was cut off at the bottom. I didn't have everything.
Okay, that's all right.
And if the solicitors would make sure your mics are on, please.
Why don't you have?
Can you hear me?
All right, good morning. We're gonna take case 21 CR 002737F, the case of Enrique. And pronounce your client's last name. I don't want to say it incorrectly.
Patriotti, Your Honor.
County, in which Mr. Petriotti is charged with 1 count of fray, 1 count of obstruction, and 1 count of simple battery with the offense date of June the 6th of 2021. Will the state briefly put the recommendation onto the record? Any other pertinent information?
Yes, Your Honor. The state, in exchange for a plea, will null pros count 1 affray, reduce count 2 obstruction to public drunkenness, 12 months to serve 1 day, credit for time served, balance probated, $100 fine, 40 hours community service, alcohol drug evaluation and treatment, probation to terminate upon completion of conditions, and no cross count through simple battery. And this will be a no one, Your Honor.
All right, Mr. Nash, was that your understanding of the agreement? And do you stipulate to factual basis ID and then?
I'm sorry, Judge, is your microphone on? You're not that loud. Or is it just me?
No,
Judge
it's
William.
hard to hear too.
Pull your microphone a little bit closer, Judge Williams.
Okay, is that better?
Much better, Your Honor.
All right, thank you. Was that your understanding of the offer, and do you so stipulate to factual basis, ID and venue?
Yes, Your Honor. I understood him to say no low contender. Is that correct?
Yes, that's correct. That's what the state has indicated.
Yes,
All right.
ma'am.
Mr. Petriotti, will you please raise your right hand? I'm gonna ask you some questions to make sure that this plea is voluntary. Do you swear and affirm that the testimony you give for the limited purposes of taking the plea will be the truth to the best of your knowledge under the penalty of perjury?
Yes, Your Honor.
All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, Your Honor.
Are you satisfied with your attorney's representation?
Yes, Your Honor.
And do you understand that by taking a guilty plea, you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, Your Honor.
And you also understand that you're giving up your right to trial by judge or jury?
Yes, Your Honor.
And has anyone promised you anything in exchange for taking a plea?
No, Your Honor.
Did anyone force you to take a plea today?
No.
And do you fully understand the requirements of what you need to do as part of your sentence?
Yes, Your Honor.
And do you understand that by taking a guilty plea, it may affect other aspects of your life that I might not be able to anticipate, such as immigration, probation, or employment?
Yes, Your Honor.
As-
No, was that right, Your Honor? No.
Well, yes, no, my apologies, Ms. Nash.
That's right.
All right. As to the charge of public drunkenness, how do you plead?
No.
No low.
I accept your no low plea at this time. Is there anything additional from either the state or the defense?
No, Your Honor.
No, Your Honor.
All right, he does need to fill out the probation sheet, correct? I don't
Yeah.
see,
I got a link yesterday from
okay, long as you have it, I just didn't see that in his staff. All right, does that conclude your business, Mr. Nash?
It does, Your Honor.
All right, you and your client can both be excused. Take care, have a good day.
Your Honor. Have a good day. Appreciate you.
All right, we can now begin with the motions. Has the officer arrived?
Yes, Judge, he's.
All right, we're gonna take up case 21 CR 005822A, in which Mr. Duarte is charged with driving under the influence, reckless driving, and I believe illegal parking with the offense date of October the 23rd of 2021. Mr. Sullivan, you're the moving party in several of these motions. Is that correct?
Judge, I'm sorry, it's hard to hear you.
I'm sorry, I'll speak louder. Mr. Sullivan, you are the moving party for several of these motions? Is that
Yes, Your Honor.
correct? All right.
Your Honor, would you like me to address what we'd like to cover today?
I'm sorry, say that again. I
Would
think
you
the
like me-
plastic is making it hard to hear. Uh-huh.
Would you like me to address what we'd like to cover today?
Yes, please. That would be great.
Judge, I believe, the Supreme Court of Georgia in Ammons and in Elliott has taken care of a fair amount of this case. Mr. Duarte refused field sobriety and a portable alcohol sensor, and the Ammons case excludes that unless the state disagrees with that. That's what the Supreme Court says. Also, we did file a motion to suppress a breath test refusal. Elliott takes care of that. I don't think there's any Miranda issues because it was a pretty quiet after arrest. If something pops up, I'm sure Ms. Waldrop and I can figure that out. So what's left is a reasonable articulable suspicion for the stop, probable cause for arrest. The officer did reread the implied consent notice for blood, to which my client refused. And so we have a constitutional motion on that. And I can, when I finish my argument on the constitutional motion, Judge, I can file a brief with the court later today if the court wants me to.
Okay. The brief may not be necessarily. Usually after argument, I just ask for proposed orders. And if those orders contain the cases, I go back and read those and just make sure. It's a little
Sure.
easier than having to do a whole brief. All right.
I have it mostly prepared, but it's.
And Your Honor, if I may?
Yes, you may, Ms. Waldrop.
Thank you, Judge. Okay, so I did hear a refusal to an alcohol sensor that you mentioned, but I did not see where that was offered, so I think that's moved.
That's right.
With regard to the refusal to the field sobriety evaluations as well as the breath test, state obviously will stipulate that those refusals are out and that we cannot use those. We do understand that. With respect to the body cam, because the officer does read implied consent and ask for breath at some point, I'm gonna stop the video at 1938. And then I'm going to repick it up for his reading of the implied consent at 2045, if that's okay with the court and with the defense counsel, so that we don't get that reading of implied consent for breath in there. Other than that, Judge.
We'll actually stipulate that he read the notice correctly, so we don't have to bother with the video at that point anyways.
Okay,
Okay,
Then
I think
in that
that
case-
works for all of us.
absolutely, Judge. And in that case, I'll stop the video at 1938,
Okay,
which is at the point of arrest and then begins the reading of implied consent. Other than that, Judge, I do have reasonable articulable suspicion, probable cause listed as the issues being challenged today. With respect to direct exam, I will do that, and my co-counsel, Mr. Birch, will give argument to the court.
okay, understood.
All right. With that said, the state is ready to proceed, Judge.
All right. And does our technology work so that we can see these videos? Would you like to try, Ms. Waldrop, before we begin?
I hope so, Judge. I did
I
log on
hope
to.
so as well.
You're the co-host, Ms. Waldrop. You should have sharing rights now.
Okay.
Okay, well, if that works, then that's fine. Please begin then. Please proceed then, Ms. Waldrop.
Okay. Mhm. Okay, and I'm just trying to set this up. Good morning, Deputy Nguyen. Do you want to come up to the microphone for us? Oh, wait, the deputy, she's gonna swear you in.
Okay, so she's supposed to be here, her attorney will be here, I just want to make sure. She's position two. Please swear him for us.
Sir, could you please raise your right hand? Please state your name for the record.
Dominic Nguyen, DOMINIQUENGUYEN.
Do you swear or affirm that the testimony you provide today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am, I do.
Thank you.
Good morning, Deputy Nguyen. Can you tell the court, how it is that you are employed?
I am currently employed with the Forsyth County Sheriff's Office as a deputy sheriff too.
Okay, and on October 23rd of 2021, were you employed with the Forsyth County Sheriff's Office?
No, ma'am, I was not.
Okay, where were you employed at that time?
I was employed with the City of Johns Creek Police Department.
Okay. And how long have you been employed in law enforcement?
A little over 5 years, ma'am.
And are the Forsyth County Sheriff's Office and Johns Creek Police Department the only places that you've worked?
Yes, ma'am.
Okay, and are you post certified?
Yes, ma'am, I am.
Okay, and can you tell the court just a little bit about your experience as a Johns Creek police officer, including your assignments, your duties? And things like that?
Yes, ma'am. During my tenure with the Johns Creek Police Department, I went through the police academy there up at the Gypsy Pickens satellite campus. I spent about 3.5 years on Uniform Patrol Division on night shift. During my time with the Johns Creek Police Department, I attended standardized civil sobriety classes, advanced roadside impaired driving enforcement classes. Towards the end of my career, I also went through the Georgia Drug Recognition Expert Program class, as well as a lot of reconstruction classes for accident reconstruction.
Okay, but that advanced roadside training, that was after you had already left the Johns Creek Police Department, correct?
No, ma'am. I obtained all of my classes in regards to impaired driving enforcement at the Johns Creek Police Department.
Okay, but it was after the incident that occurred on October 23rd, 2021, for which we're here today, correct?
Just the DRE classes after.
Okay.
Yes, ma'am.
And as a patrol, as an officer in the patrol division, what were your duties?
My main duties was to patrol assigned areas or zones, respond to calls for service, document any incidents or criminal activity, as well as proactive criminal detection and deterrence.
Okay. As part of the training that you talked about, did you have the opportunity to participate in wet labs?
Yes, ma'am.
Can you tell the court what those are?
Wet labs is a part of the curriculum for standardized field sobriety class. It helps expose students to the effects that alcohol has on various people in a controlled setting.
Okay, and so those particular subjects, they were under the influence of alcohol?
Yes, ma'am.
Okay, was the amount of alcohol known to you as an officer?
No, ma'am.
Okay, and what specifically did you do with the subjects?
Well, through the standardized field sobriety class, we were tasked with learning the standardized field sobriety evaluations as well as administering them on those controlled test subjects.
Okay. And with respect to classroom hours for FST training and ARID training, how many hours was that?
Field sobriety training was 24 hours and the ARID training was 16 hours.
Okay, and let's talk a little bit about your hands-on experience. How many arrests, DUI specifically, have you made in the field?
Approximately 37.
Okay. Does every stop that you make always result in a DUI arrest?
No, ma'am.
Would you be able to estimate how many stops you've made?
Well over 100, if not thousands.
Okay. And on October 23rd, 2021, at or about what time were you on duty?
On October 23rd, 2021, I was working from 6 p.m. the day prior to 6 a.m. the next day.
And were you in uniform to include your badge?
Yes, ma'am.
And were you in a marked patrol vehicle?
Yes, ma'am, I was.
Okay. Did you have the opportunity to encounter that particular morning a white Cadillac Escalade?
Yes, ma'am, I did.
Approximately what time did you encounter that vehicle?
Around 3 in the morning.
Okay. And how was it that you came to be in that area? Well, let me ask you first, what area were you in?
I was in the area of Sergeant Road and Finley Road.
Okay, and is that squarely within the bounds of Fulton County?
Yes, ma'am.
Okay, how was it that you came to be in that area?
Well, prior to around that time, I was assisting another officer with another traffic stop. And I had left the scene after I had concluded my assistance with that officer.
I'm going to ask you a couple of questions about your body cam.
Yes, ma'am.
Was your uniform equipped with a camera?
We'll stipulate to the foundation of the body cam.
Okay. Then, Your Honor, the state would tender into evidence State's Exhibit 1, the body cam of Officer Nguyen.
No
Any
objection.
objection? All right, thank you, Mrs. Sullivan.
Now, when you encountered the white Cadillac Escalade, Deputy Nguyen, what first drew your attention to it?
What drew my attention to that vehicle was after I had left the previous scene. I was traveling down Finley Road at around St. Amour Place. I then noticed that white Cadillac Escalade parked next to the stop sign with its headlights turned off.
And did you state that it was impeding the roadway? Or?
Yes, ma'am. It was parked next to the stop sign, and that's in violation of Georgia law.
Okay. And what did you see with respect to the driver of that vehicle?
So when I observed the vehicle sitting there initially, it was sitting next to the stop sign with no headlights on. As I passed the vehicle, I was able to observe it in my rearview mirror. I then observed the headlights turning on and the vehicle pulling out into the roadway. And then it stopped abruptly and backed up back to where it was. I then made a U-turn on Finley Road to go approach that vehicle. As I approached the vehicle, I notated or observed it was a white Cadillac Escalade, and I observed a sole occupant driver exiting from the driver's seat.
Okay. And at that time, did you encounter the driver of the vehicle?
Yes, ma'am, I did.
Okay. And who did you learn that person to be?
He was later identified as Mr. Joseph Duarte.
Okay. I'm going to play you your body cam from that morning and then ask you questions.
Yes, ma'am. You all right?
It's like a real. There's an accident right there?
No, sir.
Oh, I was telling my wife guy came here and pulled around.
The tow truck?
Yeah.
Yeah.
Say, the tow truck came. It's still over there, sir.
What are you talking about?
See the orange light?
The orange light? Which light are you talking about?
Blue light. See the orange light right there? Wasn't there like an accident right here?
Are you talking about just right now?
No, like, sir, not right now.
I don't know what you're talking about, sir.
It's okay. I apologize.
What are you doing out here?
I live right there. I'm just walking back home now.
Is that your car?
Sir. I live right there.
Okay.
I was pulling up this road and I saw all the flashing lights
Yep.
and I got nervous, so I pulled over and I got out the car.
Why are you parked at another neighborhood?
Because I live right here.
All blacked out.
No. Don't say it like that, sir.
I'm just calling it as I see it, sir. There's a car. There's a dark car. I drove by. There's a dark car parked at an entrance of another neighborhood. You turn your headlights on as you pass,
I live right
and
there.
as I'm stopping there, you're backing up, and then you're sitting there.
I
again.
wasn't back. Sir, did you just come from here when there was like a big tow truck?
Yes, sir.
Okay, so when I couldn't pull there, so I actually came this way and I pulled back and I was waiting. I was on the phone with my wife and I told her.
Where are you coming from today?
Sir, can I just finish what I was saying? I told my wife there's a big tow truck and I gotta wait. And that's why I was pulling right there. And you saw the tow truck pulled in there and came out and then you went by.
Yep. I went by,
And
you
I was
turned your
still-
headlights on, you pulled out,
No, I didn't.
and as I
didn't-
passed you,
didn't
you
pull
backed
out,
up.
sir.
Okay, that's fine.
I did turn my headlights on.
Where are you coming from today?
Sweetheart, can you come get me on? Can my wife please, just please come get me on Finley Road?
Why can't you just drive home?
Can you please, can my wife just please come get me, sir?
Why can't you drive home?
I know, but it seems like you beating me up.
Well, sir, like
The
I
tow
told
truck
you,
was right there.
it wasn't
tow
blocking.
truck-
If you're trying to go this way, it's not blocking your lane of traffic.
But I didn't know that because it was all the bright lights, sir.
Where are you coming from today?
Stace, can you please come get me on? Please. Can you please come get me on?
Sir, you're not making any sense. I need your ID from you.
Okay, I'll give you my.
210.
Sir, my wife
I
is
need your
coming.
ID from you.
I'm gonna get it, sir.
Jose?
Yes, baby. Please come get me.
Show me out on a suspicious person and vehicle at Finley Road and Sanamore Road.
Right there, sir. Can you please come get me? He said I'm suspicious, but you live right. You'll see 450. He's come. Just come, TG. I'm standing right here.
Where are you coming from today? You still haven't answered that question. Where are you coming from today?
I was coming from the Kroger, sir.
Which Kroger? Hang up the phone. You're being detained right now. Hang up the phone. You're being detained right now.
So, I'm just trying to hang it up because my wife, she's on the way.
Where are you coming from today?
I was coming from the Kroger.
Which Kroger?
You know where the UPS is and the Chick-fil-A. It's like 2 minutes, literally 2 seconds from here.
Okay, the Medlock Bridge and McGinnis Ferry? Or the Peachtree Parkway and McGinnis Ferry?
Can I just turn around and show you? If you go up this road, it's gonna dead end. You make a right. When you go up to the right, there's a McDonald's on the left. The Kroger's right
Okay,
there.
I'm familiar. So you're coming from Kroger at
3 in the morning? I need you to hang that up for me.
It's my, can I?
I don't care if it's your wife. I need you to hang that up for me. You're being detained right now. Hang up. Thank you.
Can I turn it off? Or you want me?
You can turn. That's fine. Whatever.
I'm coming from. I was coming from another place.
Where were you coming
Obviously,
from?
no, it's not true. I was coming from a place called Bliss.
You're coming from Bliss. Okay. So the reason I'm asking is I can smell the odor of alcoholic beverage coming off of you while you're standing outside of my car. Okay. How much alcohol have you had to drink today?
Not much, sir.
How much is not much?
I mean, I live right there. I wasn't
How much is
driving.
not
I was
much?
walking.
Mr. Duarte, how much?
I haven't had, sir. I don't want to talk to you anymore.
That's
I'm
your
just
vehicle.
walking.
That's your vehicle, right?
Please.
Answer my questions. You're not making any sense to me. You said you were driving home. You saw a big tow truck, so you were blocking the way, so you backed up and you parked over there, right?
No, that's not what I said, sir.
What did you say? How did you get to Kroger from Bliss, and how did you get from or Bliss to Kroger, and how did you get from Kroger to here? Is that your car?
It's been parked there because there was a tow truck in the,
Is that your car? Are you telling me that you're illegally parked over there as well now?
Well, I didn't know. I was trying to go home, and there was a tow truck, so I just sat there. I've been there for like 2 hours.
You've been there for 2 hours?
You can check my phone log. I called my wife at least an hour and a half, 2 hours ago.
Just because you called your wife an hour, 2 hours ago doesn't mean that's when you were driving.
I know, but I called to tell her that I couldn't get home because I'm sure she was.
And then when I pulled up, you were in your car as well.
Sir, when you didn't pull up, you drove down the street. I thought. Okay.
And I came back, and you were in your car, and you got out of your car when I drove up to you.
No, sir, I was not in my car when you drove past.
But that is your car then, right? That white Cadillac?
It is.
That's your car?
And I pulled.
How did it get there?
I pulled it in the road because there was a tow truck. When I was coming up.
That tow truck wasn't here for more than like 10 minutes.
Sir, it was. Really, sir?
Okay.
When I pulled up, there was I didn't realize it was a tow truck.
And what did you think it was?
All I saw was a bunch of flashing lights. I told my wife it was an accident. I thought it was an accident. Sir, you're a cop, so you're okay. It just seemed like they were driving kind of fast. Oh, that's my wife.
That's cool. You need to move on.
Stacey,
no, man.
Please move on. Yeah, don't get in no trouble, please.
I'm not, just ask me what I.
That's fine. You can just get out of the roadway, please.
Stace, be careful, baby. Okay, he said you cannot park there. I don't want my wife to get in trouble, please.
That's fine. So you're coming from Bliss. You went to Kroger, or did you go to Kroger at all, or was that a lie to me?
I 100%.
Do you understand why now I'm asking these questions and I'm acting the way I am? Because your story fell apart from as soon as we walked from your car up to here to Kroger and now Bliss. Are you going to give it to me straight? Okay. So let's start over.
I was coming down this road. I saw a bunch of lights and I pulled in there.
Okay.
I called my wife and I said, I think there's an accident there.
Okay.
Because
and you're coming from Bliss. Is that correct?
I was coming from Kroger. I went to Bliss.
Okay.
Or Quick Trip. I keep saying Kroger, but I'm thinking gas station. But, sir.
So how much alcohol have you had to drink today?
Sir, I pulled into the driveway there because there was a big truck there.
Joseph, it's a simple question. How much alcohol have you had to drink today?
So you know that 450 Wellberry Court is like right there.
You still haven't answered my question. I'm not asking how far 450 Wellberry is. I'm not asking where you're coming from. How much alcohol have you had to drink today? Simple question.
I have no idea. I mean,
you don't know?
I had two. Well, I went out. The first place I went to was Avalon.
All right.
I went to the MF bar. I had sushi. I had sushi and I had a drink there.
Okay.
And then I went to a place called Wine Me Down. I didn't have anything to drink there.
Okay.
Then I went to Bliss. I think I had a couple of drinks there. So
okay.
I don't know, maybe 3 drinks.
So 3 drinks over the span of over the span of the night.
Mhm.
So from Avalon to Wind Me Down to Bliss, you had 3 drinks over the night. And when did you go to Avalon? What time did you get there? Keep your hands out of your pockets, one.
Sorry. It was just my glasses.
That's fine.
And I put it behind my back.
That's fine. Just keep it out of your pockets. About what times did you get to Avalon? You don't have an answer?
I think that what I really don't want to talk anymore. I'm
You don't want to talk any further?
Yes.
You mind doing some field sobriety exercises?
I wasn't driving, sir, so
That's not what you told me.
that is exactly what I told you. And I don't want to do any tests. So if you want to take me in, I understand. I didn't do anything. I was standing outside my car. I put my lights on when I saw because the tow truck, it looked like it was going to hit me. I think you saw it pull into where I was parked, waiting, because I saw the lights.
How long ago was your last drink?
Okay. So I know you're going to take me, and that's it. I'm done.
Well, I'm trying to figure out. Look, Mr. Joseph, I'm not trying to take you. You know, okay. So let me back up. Taking people to jail is taking somebody's liberty away, right? I take taking somebody's liberty away very seriously, and I want to make sure I have the right guy with the right charges. I don't want to arrest an innocent guy. You know what I'm saying? That's why I'm asking all these questions, trying to figure out, trying to help you dispel my suspicion that you are under the influence of alcohol. I'm giving you a chance to prove me wrong.
Sir, I came up this road with a tow truck parked there. That's it. If you want to just pick me in, I understand.
So you don't want to do field sobriety exercises? I just want to make sure you're okay.
I wasn't driving. I was literally standing outside my car. So my wife is parked there. I called her to come get me because the tow truck was there. If you just want to take me in, I understand.
So you were driving up, you saw a tow truck, and you pulled in there and you waited. That's what you're telling me.
I saw lights there. I cannot tell you when the tow truck, because I was on the phone. I pulled in and I was on the phone with my wife, and I wasn't looking in that area. But there was a tow truck there. The only reason why I stopped there because there was a tow truck.
You can go ahead and put your hands behind your back, please. You're under arrest for DUI. Relax your hands.
Yes, sir.
T10, 1 in custody, put me a case number, please. Go ahead and stand in front of my bumper for me, please.
Yes.
Joseph, do you have anything in your pockets that's going to stick me, prick me, or poke me?
No, just my glasses.
Just your glasses?
Yeah. On the right hand side.
Clear on 3906. Spread your feet for me, Joseph.
That's the glasses I told you.
Okay.
That's it.
Yeah, that's no problem. The wife isn't a problem.
Can somebody tell her to go home? I don't want her to.
So, hold one step at a time. You were in the Marine Corps?
Yes.
What'd you do in the Marines?
47
What is that? I'm an Army guy. I don't know. I don't know what all that stuff is.
Those
Do you need your glasses?
just to like see my phone, so no, I don't need to see it.
All right. So here's what's gonna happen today, okay? So we're gonna go down to the Fulton County Jail, Rice Street, down in downtown Atlanta. You can't take your phone with you. Do you have your wife's phone number memorized?
Can she just take it now?
Yeah, that's what I was gonna say. Do you need any numbers out of your phone?
No, I was just wondering, can she take my?
Yeah, so she can take your glasses and your phone.
Okay.
I'll even, if she's able to take control of your car, I'll even let her take your car home. Otherwise, I'm gonna have to tow it.
No, she can take it. My son is right there. He will come get it.
Okay. So I'll work that out with her. Do you need any phone numbers out of your phone before I give that to her?
Can I see it real quick?
And do you need any is this your wallet as well? Do you need any cards out of your
No.
anything like that?
She can keep all that stuff. Can I? Is there any way for me to just?
Is there a to swipe?
Can we swear?
Which one?
You could just.
The phone?
That's my wife. So
Stacy?
yes.
Okay. Do you need her phone number or do you have it memorized?
I don't have my wife's. I mean, she just gotta like literally. I know it sounds. I hope we're recording this stuff. That sounds crazy, but she literally just got a new phone.
If you need me to write down, so that's what I'm saying. You can't take your phone with you?
Can we press on it? Yes, that number right there. Yeah.
404-904-5793. Do you need any other phone numbers or just your wife's?
No, can we just turn that phone on?
Yeah. Do you want me to give it to her or do you want me to put it
After
back
you
in
turn
the-
it off, yeah. Let me just,
You need any cards in here?
no, sir. She can. I mean, when I need to bail out or something tonight. Or?
Yes, sir. So you'll like I said, you can't take your phone with you. If you need a credit card or a debit card, we can take that with you as well. Otherwise, the phone's gonna go back to your wife and your glasses. You need your glasses for reading or anything?
No. Just for reading.
So I'll
But the phone. I'm just asking about the credit
can I put
card.
these on you?
I can't see with them on. It's just for reading.
So I'll put these back in here because I'm gonna give you some papers.
Okay.
That way, if you want to read it.
Sure.
This is gonna be your wife. This is your
Thank
wife's
you.
phone number
Thank
as
you
well.
so
Okay.
much.
I'm gonna fold that up and I'm gonna go ahead and put that in your pocket as well. Okay.
Thank you so much.
So, Mr. Joseph, what we're gonna do from here is I'm gonna seat you in the back of my car. I'm gonna go talk to your wife afterwards. I gotta read you something else real quick.
And the car keys are there.
Yes, sir. I know it's a little weird, but I know it's hard plastic. Just have a seat in there. I'll help you in.
Thank you.
All right.
Thank you.
So I'm gonna reach around in here. So, how old are you, Mr. Joseph?
51. 52.
Okay. I'm gonna read you something real quick. I need you to pay attention, and I need an answer at the end of it. Okay.
Your Honor, just for the record, I'm going to pause it there and then fast forward to 2045. I'm sorry, Judge, I'm not sure if the court reporter heard me, but for the record, I'm going to stop at 1938 and forward to 2045.
Could you hear that, Ms. Carter?
Yes, Judge.
All right.
Your Honor, just for the record, it's 2046. I couldn't get it right there.
Privilege to drive upon the highways of this state upon your submission to state administered chemical testing of your blood, breath, urine, or other bodily substances for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your Georgia driver's license or privilege to drive upon the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be offered into evidence against you at trial. If you submit to testing and the results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver's license or privilege to drive upon the highways of the state may be suspended for a minimum period of 1 year. After first submitting to the requested state test, you are entitled to additional chemical tests of your blood, breath, urine, or other bodily substances at your own expense from qualified personnel of your own choosing. Will you submit to the state administered chemical test of your blood?
No.
Okay, that's fine. I'll be right back, okay? Let me get that phone to Miss Stacy for you.
I want to keep my phone.
You can't keep your phone.
Well, we'll just take it into evidence and I'll get it when I check out.
You don't want me to give it to your wife?
I would like, whenever I get released, I have my phone, so.
So that's what I'm saying. So I can't, the Fulton County Jail's policy doesn't allow you to take your phone in there with you. If I take it with me, I've got to turn it into evidence at Johns Creek Police Headquarters. So you'll have to come back another time. Like, it won't be there when you get out. It'll be back up here in Johns Creek.
You can give it to my wife.
Give it to your wife? Okay. And I'll talk to her about your car as well, okay?
What was your reason, excuse me, for approaching the driver of that Cadillac Escalade?
The reason I approached the driver of that Cadillac Escalade was because the vehicle was improperly stopped at a stop sign. It was parked within 30 feet of it.
And when you first made contact with the driver, it stated to you, I saw flashing lights and I got nervous. Is that correct?
Yes, ma'am.
Did he explain to you what it was he was nervous about?
He never really explained in detail. He just kept talking about a tow truck and flashing lights, and he got nervous seeing those things.
And approximately about 3 minutes and 55 seconds into your encounter with the defendant, you requested his ID, his driver's license. Is that correct?
Yes, ma'am.
And why did you ask for his driver's license?
Well, based on at that time, based on the totality of everything I had observed, the traffic violation, and as I was speaking with the driver from inside of my patrol vehicle, I was able to detect the odor of alcoholic beverage emanating from his person.
Did the defendant comply with your request?
Yes, ma'am. He provided me with his driver's license as I exited the vehicle.
And during your interaction with the defendant, how close were you to the defendant on scene?
Within arm's reach.
And you stated that you noticed an odor. Did you identify that odor as alcohol?
Yes, ma'am, an alcoholic beverage.
And how would you describe it in terms of its strength?
I would describe it as a moderate odor of alcoholic beverage.
And specifically, as you're speaking with the defendant, where did it appear to be coming from?
It appeared to be coming from his breath.
And did you ask the defendant whether he had had anything to drink?
Yes, ma'am, I did.
And what was his response?
He was a little evasive at first, but eventually he ended up telling me approximately 3 drinks.
Did he state specifically what he had to drink?
No, ma'am, he did not.
We heard him indicate to you that he had been at Avalon. What is that location?
Avalon is a shopping and entertainment center within the city of Alpharetta. Based on my own personal knowledge, I knew it to, have different drinking and eating establishments within its campus or its area.
Okay. Is the MF bar one of those establishments?
I believe so.
Okay. And how many drinks did he state that he had there?
The driver stated he had a singular drink.
Okay. And from the MF bar at Avalon, where did he go?
He stated to me he then went to a place called Wami Down.
And did he indicate that he had had anything to drink there?
He did not, no, ma'am.
And was there any other establishment that he patroned that night?
The driver told me that he ended up going to Bliss after Wami Down.
Okay. Did he indicate that he had had any drinks there?
Yes, ma'am. He said he had approximately a couple drinks.
Did you make any observations about the defendant's appearance, specifically his face or his eyes?
During my encounter with the driver, I observed that he had bloodshot and watery or glassy eyes.
At what point did your encounter shift to a DUI investigation? Or excuse me, let me ask this way. Did this start out as a DUI investigation?
No, ma'am. I know the circumstances with the, I guess, initiation of this encounter were a little unorthodox, but it was more akin to a traffic stop, even if it wasn't presented like a routine one. But it shifted closer more toward the impaired driver investigation about when I exited my patrol vehicle, based on the odor of alcoholic beverage emanating from his breath and the other circumstances with his responses towards my questions.
Okay. I want to go back to the early part of the video. He stated that he had come that way and pulled back and was waiting. Did the defendant ever indicate to you what he
I'm
was
sorry,
waiting?
Judge, hold on 1 second, please. Thank you.
So he indicated that he had come that way, pulled back and was waiting. Did he indicate to you what he was waiting for?
No, ma'am, he did not.
Okay. Do you recall approximately how many times you had to ask the defendant where he was coming from?
I don't have a number, but several times.
Okay. The defendant's responses to your questions, would you describe them as non-responsive?
They were evasive and elusive. He never answered my questions directly. He always just kind of repeated the same answer over and over again.
Did that have a bearing on whether or not you believe the defendant to be telling you the truth in response to the questions you were asking?
I'm going to object. That's speculative.
Rephrase, Ms. Waldrop.
As you were speaking with the defendant, did you get the sense that he was being honest with you?
Not completely, no, ma'am.
At 7:54 on the video, you stated that the tow truck wasn't here for more than like 10 minutes. What was that in response to?
The driver had stated to me he had been sitting there for approximately like 2 hours, based on my own personal knowledge because of the previous traffic stop that I was assisting with. I knew that the tow truck had arrived at about 2:53, and this encounter began around 3:01. So it was there less than 10 minutes.
Do you recall how many times you had to ask the defendant what he had had to drink?
Several.
Do you recall asking the defendant how long ago was his last drink?
Several as well.
Deputy, when as an officer, as a law enforcement officer, have you had the occasion to observe people under the influence of alcohol?
Yes, ma'am, I have.
Okay. And what about as just an individual layperson?
Yes, ma'am, I have.
And how many times would you say you've had the opportunity to observe people under the influence of alcohol?
Hundreds of times I'd venture to guess.
Okay. And can you just describe briefly a couple of those instances where you were able to observe individuals under the influence of alcohol?
Through the course of my duties, as far as a law enforcement officer goes, with the investigation of impaired drivers, also on various calls for service where several other people are under the influence of various substances, and my own personal experience.
Okay. And based on that, were the manifestations that you observed when you arrested the defendant consistent with someone who was under the influence of alcohol?
Yes, ma'am, I would believe so.
Okay. And based on your experience and your training and what you observed of the defendant that morning, did you have an opinion as to whether or not he was under the influence of alcohol to the extent that he was less safe to drive?
Yes, ma'am, I did.
Okay. And what was your opinion with regard to that?
I believe that he was impaired and less safe to drive.
Okay. And did you place the defendant under arrest?
Yes, ma'am, I did.
And for what offense?
For driving under the influence.
Okay. And you read the defendant implied consent?
Yes, ma'am, I did.
Okay. And what section did you read?
I read for the suspect's age 21 or over.
Okay. And how was it that you determined his age?
I had asked the driver his age, and he had told me 51 and 52.
Okay. Was that Mr. Huerta's age at the time?
At the time of the report and the arrest, once I completed my report, it was determined he was 53 based on my entry into the report system.
Okay. And when did you read the implied consent warnings to the defendant?
Shortly after placing him under arrest.
And did you read it verbatim?
Yes, ma'am.
Okay. And Your Honor, I believe defense counsel has stipulated to the implied consent.
That's correct.
Go ahead in it.
So admit it.
Evidence. And specifically, what test did you ask for at the mark of 2045?
I asked for a chemical blood test.
Okay. And what was the defendant's reply?
He refused, stating no.
Okay. And did you observe the defendant in physical control of that white Cadillac Escalade?
Yes, ma'am, I did.
Okay. Nothing further at this time from the state.
Mr. Sullivan?
Thank you, Judge. Prior to this stop, you were assisting another officer on a traffic stop, correct?
Yes, sir, I was.
Now, was that on Finley Road or Sergeant Road? Do you remember which road that was on? Right outside?
I believe it was Sergeant Road, but in that area, yes, sir.
Okay. Was that the road that we see on the video?
So I believe the previous traffic stop was on Sergeant Road, which is the road that the video was on my body camera was Finley Road, and Finley Road intersects with Sergeant a little ways down.
Okay. Sergeant Road, is it a 2-lane road?
Yes, sir.
Okay. With the double stripe median going down the middle of it?
Yes, sir.
Was the traffic stop on the road? The previous traffic stop?
Yes, sir.
Okay. Now you indicated the tow truck arrived and was there for about 10 minutes, but the traffic stop itself lasted longer, correct?
Correct.
Okay. And then when the tow truck came, it basically did its business and pulled into the neighborhood where Mr. Duarte was and did a U-turn and went out. Is that right?
Yes, sir.
Okay. All right. He was definitely nervous, right?
Yes, sir.
Okay. And You asked him a bunch of questions and made him more nervous, right?
Yes, sir.
Okay. And then at some point he he decided that he had enough and was not going to do your field sobriety evaluations, right?
Correct.
When you read him the notice, part of the notice, and hopefully I get this right, Your Honor, if I may snag the implied consent
No
notice.
problem with that. And Mr. Sullivan has that.
Thank you. Well, this is kind of blue, but it's a green notice.
Yes, sir.
Right? Um, you read it verbatim, and of course, the statutory language, it says if you refuse this testing, your Georgia driver's license or privilege to drive on the highways of the state will be suspended for a minimum period of 1 year. And then after that, it says your refusal to submit to blood or urine testing may be offered into evidence against your trial. You read that too?
Yes, sir. I did.
That's part of the notice, which is part of the statute.
Yes, sir.
Handing the exhibit back up, Your Honor. And he said no to the blood test.
Yes, sir. That's correct.
Now you indicated you made a number of DUI arrests and more so after this arrest, right?
Yes, sir.
This is nothing that there was no exigency in this particular case as with regards to any other case that you've done, right? It's just an average DUI stop.
Yes, sir.
Okay. One moment, Judge. This was 3 o'clock in the morning?
Around, sir. Yes, sir.
Okay. Did you ever ask Mr. Duarte if he had any allergies?
I did not know, sir.
Did you ever ask him when was the last time he slept?
No, sir. I did not.
That's all I have, Judge.
All right. Any redirect, Ms. Waldrop?
Your Honor, just briefly, if we could just allow James to share screen, just for purposes of demonstrative purposes, I just kind of want to get an idea of where he was parked in relation to where his residence was, if that's okay.
All right.
If Mr. Glanville would give me host access, I could share my screen. Or co-host.
It's done.
Deputy Wynn, and if you need to come over to the screen, that little red dot, is that an accurate depiction of where this vehicle was stopped when you encountered it first?
It was more so on Santa Monica Place, but this intersection, yes, ma'am.
Okay, that intersection.
I can't hear his response.
It was more on St. Amour Place, but in that intersection, yes, ma'am.
Okay, and the defendant kept stating to you that he wasn't driving, he was walking and he was going home, he was headed home, correct?
Yes, ma'am, that's correct.
Okay, so where was the defendant's residence in relation to that location, as far as how far it was distance?
Based on his driver's license information, the address provided, I believe, was 450 Wellingborough Court. Per the Google Maps, it's approximately a mile away from where the stop location was.
Okay, do you see that on the map?
I believe it's
Okay. Okay, all right. Nothing further, Judge.
Anything, Mr. Sullivan?
Yes, Your Honor. I hate to bring it back up to the screen. Where was your previous traffic stop?
And make sure I can see when you stand there, I can't really.
the previous traffic stop was in the area of Sergeant Road and Finley Road.
Okay.
Okay. You need back up there?
Yeah. Sorry. So it was when I guess if you're coming from Finley Road, would you make a left on the Sergeant Road? Or is that where the traffic stop was? The previous traffic stop?
Yes, sir. It would be, if you're coming up Finley, it would be over here.
Okay. In Wellingborough Court, I guess if you look at this Google map, you take a left on Sargent and looks like another left on Crossington Road to get into that neighborhood, right?
Yes, sir. That's correct.
Thank you. That's all I have, Judge.
All right. I'm sorry, Judge, just one more question. Would the defendant have had to drive through that intersection in order to get home?
Yes, ma'am, he would have.
Nothing further, Judge.
Anything, Mrs. Sullivan? Can this
No,
witness
Judge.
be excused?
Yes, Your Honor.
Thank you. We appreciate your time this morning.
Thank you, Judge.
All right, take care.
You as well. Thank you.
All right, I forget, Mr. Birch is gonna do the oral argument, is that correct?
Yes, Your Honor.
Please proceed.
State waves opening.
All right.
Judge, do you mind if I stand over?
Or wherever it's best.
Thank you, Your Honor. You better without this in my way.
It's difficult for me to see you there as well, so that's good.
Your Honor, I obviously had a chance to view the video and listen to the conversation yourself. There was a traffic stop prior to this traffic stop. Every indication was that this traffic stop was on Sargent Road, just up from Finley to the left. That's in the direction of Mr. Duarte's house, the way he was supposed to take home. The officer admitted that Sargent Road is a two-lane road, and the previous traffic stop was on the roadway, which means if Mr. Duarte were to travel that way, his direction travel is blocked by that prior traffic stop. He couldn't go that way. So the reasonable inference is he waited. He waited in his neighborhood for the traffic stop or whatever it was, but he thought it was an accident, which is reasonable because there was a tow truck that arrived there. The tow truck actually drove into the neighborhood where Mr. Duarte was to turn around. And then shortly after that, of course, the officer initiated the traffic stop on him as he started to proceed forward. What the state has is a nervous defendant who had an odor of alcoholic beverage about him. That's it. And I submit to you that, and even including in the jury charges that we provide jurors during trial and even on probable cause cases, that odor of alcoholic beverage is not enough. Even arrest someone for DUI. There's not enough evidence to arrest him for DUI. I submit to you that he's waiting for a traffic stop to clear, which there was blocking the road, that there was no reason to detain him because he had nowhere to go. His access or travel to his home was blocked by the officer's previous traffic stop, by the tow truck. Once the tow truck went into his neighborhood, the neighborhood where he was at, and turned around, then he started moving. So I submit to the court, there's no probable cause to arrest for DUI, and there's not even a reasonable suspicion to even stop his vehicle. Now, getting to the blood test refusal, there is, and if I can get can you hear me that piece of video right there? That was good. I have to give kind of a history lesson with regards to the current status of the DUI law and the implied consent notice. It really goes back to a case called Schmerber versus California. That's 384 US 757. That's in 1966. Went up to the United States Supreme Court. Mr. Schmerber was arrested at a hospital while receiving treatment for his injuries from a car accident. Blood was drawn for law enforcement purposes from Schmerber without obtaining a search warrant. And there was an indication in the Schmerber case that there was just not enough time to get a search warrant. By the time they would have gotten one, the alcohol would have dissipated from the system, making the blood test result meaningless. So they just got it. Schmerber was widely interpreted, including in the state of Georgia, that in every DUI case, there's exigent circumstances. Alcohol dissipates from the body rapidly. You don't need a search warrant. In Strong versus the state, that's 202 Southeast 2nd 428. That's a 1973 case. That was a case out of Georgia, where blood was taken from Mr. Strong. He was unconscious and was used without a consent and without a search warrant. And the Supreme Court of Georgia interpreted Schmerber that taking the blood was considered appropriate incident to his arrest, and hence not an unreasonable search and seizure. And the legal analysis in Strong found that the evanescent nature of alcohol in the blood made it necessary to have a sample extracted to prevent the failure of justice from a certain disappearance of this evidence. Later on, in State versus Highsmith, 190 Georgia Appeals 838 at 839, that's a 1989 case. The Georgia Court of Appeals simply took the position that in Georgia, the state may constitutionally take a blood sample from a defendant without his consent, citing Strong, and then it says our implied consent notice thus grants a suspect an opportunity afforded to him by the Constitution to refuse to take a blood alcohol test. And then 40 as found as 55 actually grants rather denies a right to a defendant. Now, Highsmith was addressing what it was addressing was the right to refuse the test pursuant to the implied consent notice. And so these cases kind of bypassed general Fourth Amendment law and carved out a DUI exception that essentially in every DUI case, you don't need a search warrant because alcohol dissipates from the body rapidly. That all changed in a case versus it's called Missouri versus McNeely, and that's 133 Supreme Court 1552 that came out in 2013. McNeely was arrested for DUI in Missouri, of course, was read their version of the implied consent notice. Of course, he says no. And the officer just takes him to the hospital and has a nurse draw blood from him without a search warrant and without his consent. McNeely actually won at the trial court and at the state Supreme Court level, and the state appealed it to the United States Supreme Court. And what the United States Supreme Court did was essentially reset this misinterpretation of Schmerber back to what Fourth Amendment law is in every other criminal case. On equal footing, no longer weird carved out exception that was interpreted apparently wrong from Schmerber for all these years. And what they said, yeah, there are some circumstances where there are exigent circumstances, but those are rare. It's so easy to get a search warrant in most places. A magistrate's available 24 hours a day, just like it is essentially here in Fulton County or most places in Georgia. So you either get, so it's easy to get a search warrant, very rare circumstances for exigent circumstances. So McNeely reset everything back to general Fourth Amendment law, where basically there's, again, there's three ways to do a search. One is through voluntary consent. Next is the one we all know of, go to a magistrate or judge and get a search warrant if you have probable cause. And the third way is still exigent circumstance, like with any other Fourth Amendment search, but that's a rare exception for it. And so, of course, once the Supreme Court of the United States makes this ruling, the states filter it out over the years and adopt what the United States Supreme Court says is the law of the land. And of course, the Georgia Supreme Court did that in Williams versus the state. That's 296 Georgia 817 that came out in 2015, essentially agreeing that Fourth Amendment law with regards to DUIs is brought in line with everything else. There's no longer a DUI exception as opposed to other Fourth Amendment cases. Then came Olevic versus the state, and I know this is a blood test case, and Olevic was, I believe, a breath test case. Olevic, which is Olevik, versus the state, BO2 Georgia 228, come out in 2017. This is important because it was the first time in a DUI case that the court recognized Article 1, Section 1, Paragraph 16 of the Georgia Constitution applies to in-custody breath test. And they stated for the first time that the defendant has a right under the Georgia Constitution to refuse to be compelled to submit to an act. And that's a right that is actually not granted on the Fourth Amendment of the United States Constitution with regards to breath tests. That Birchfield kind of said breath tests are not, they are minimally invasive, kind of like fingerprints. However, Olevic did not undergo Fourth Amendment analysis for the admissibility of the breath test. Like I said, the Birchfield case kind of took care of that. But what Birchfield did, and Birchfield, Your Honor, is Birchfield versus North Dakota, 136 Supreme Court 2160. It's a 2016 case. It's actually a combination of cases. Part of Birchfield held that blood tests are significantly more intrusive and subject to a Fourth Amendment search analysis. In 2019, the Georgia Supreme Court held in Elliott versus the state 305 Georgia 179 that when someone exercises their right on Article 1, Section 1, Paragraph 16 of the Georgia Constitution to refuse to voluntarily submit to a breath test, that refusal to submit to the test cannot be held against a suspect in a criminal trial. And this is the first time this right has been extended to DUI cases. First time. Exercise a constitutional right under the Georgia Constitution that can't be held against you at trial. And that was extended, of course, with AWAD versus the state. That's AWAD 313 Georgia 99. That's a 2022 case, extending Article 1, Section 1, Paragraph 16 to state administered urine tests. And then again, last fall in Ammons versus the state 315 Georgia 149. That's a 2022 case, extending that right to pre-arrest field sobriety and portable alcohol sensor. You exercise your right to refuse to voluntarily submit to those. That can't be used against you at trial. Now you're going to say, that's great. Those are deal with acts. This is a blood test refusal case. And it's, I know it's hard because for many years, and I was a prosecutor too, we always thought that refusals could be used against someone at trial. There's a statute that says so, even though Elliott and Ammons now says that it can, an AWAD, for compelled acts. There is a body of case law out there that deals with the Fourth Amendment. And our appellate courts have already held that a refusal cannot be used against a defendant in a criminal case if they exercise their right to not voluntarily submit to a search absent a search warrant. In United States versus Runyon, 290 F 3rd 223 Fifth Circuit 2002. The Fifth Circuit held that a refusal to voluntarily allow a search of a computer cannot be used against a defendant at trial. Already out there. It's case law. Here in Georgia, in Mackey versus the state, that's Mackey versus the state, 234 Georgia Appeals 554. That's a 1998 case. And if you read Mackey, you got to keep this in perspective because this was pre-Missouri versus McNeely. And Mackey was a DUI case, but part of Mackey dealt with the search of the vehicle that turned up drugs, I believe. And Mackey refused to voluntarily consent to a search of the vehicle. And what the Court of Appeals said in Mackey is that refusal to submit to voluntary consent of of a search of a vehicle could not be used against Mackey at trial. Existing case law here in Georgia on that very issue, Fourth Amendment. In Gardner versus the state, 255 Georgia Appeals 489, Court of Appeals held that the trial court improperly found that refusing to voluntarily consent to a search of one's property may be used as a factor against in establishing criminal cause for search warrant. The court basically said it was error for the magistrate to consider Gardner's refusal to consent to a search of the residence as part of the basis for the issuance of the search warrant. In this case, refusing consent to search was Gardner's right. We declined to view the exercise of a constitutional right as a factor to determining probable cause. Thus, the trial court's determination that the refusal to consent to a search may be taken in account when determining probable cause is an error as a matter of law. That's a Georgia Court of Appeals case that the court couldn't even consider that part of probable cause for a search warrant. That's before it gets to trial. Mack has already said he can't use it at trial. And even if, and I'm, the officer's doing what he's trained to do, and that's statute, says he has to read the notice, which is a Georgia statute, but it's the same issue in Elliott, the same issue in AWAD. That doesn't mean it's constitutional. And the language in the notice, you're refusing to submit to blood or urine tests may be offered as evidence against your trial, is still in there. Well, we know urine can't be used against a suspect. We know breath can't be used against the suspect, and they still haven't changed the notice after the AWAD case with regards to urine. It's still in there. And there's existing case law here in Georgia that deals with other searches under Fourth Amendment. And so I just want to bear repeating that McNeely reset Fourth Amendment law. Now, the Georgia Supreme Court is addressing this issue right now in a case called State versus Randall. And that is docket number S23A1118. Oral arguments were actually heard on this matter on November 7th of this year. Randall was arrested for DUI in Athens, was read the implied consent notice for blood, and Mr. Randall refused. The trial court suppressed blood test refusal, not once, but twice. First, when it was the first time it was in the trial court granted the motion to suppress. It was appealed up to the Georgia Supreme Court about a year ago. The Georgia Supreme Court sent it back down for additional guidance. There was a rehearing in the State Court of Athens, Clark County, last spring. The judge again reaffirmed the suppression of the blood test refusal, and of course the state appealed it back up to the Georgia Supreme Court. And like I said, oral arguments were heard little over a month ago, so we probably expect a decision hopefully in the next couple of months on the Randall case. But I can't stress enough that the current existing Fourth Amendment case law here in Georgia is clear that when someone exercises their voluntary right, that their right to voluntarily submit to a search, that can't be used against them at trial, that can't be used against them in a probable cause application, and there's no difference in a DUI case. There's no difference to a search of the blood. We'd ask you that you would exclude or suppress the blood test refusal in this case as well, Your Honor. Thank you.
Thank you, Mr. Sullivan. I was trying to keep up with all the cases and read them as you went, but
Yes.
I was unsuccessful. So-
And Your Honor, I can get you a brief this afternoon. I have it pretty much.
All right, that'll work. Thank you. All right, Mr. Birch, please.
Thank you, Your Honor. So I just want to take a minute and rehash a few of the facts of this case. So it was 3 a.m. in the morning, and Mr. Duarte is coming home from what he has admitted as a night of eating sushi and then going to a few different bars in the Alpharetta and Milton, Johns Creek, area of our county. And he comes upon a traffic stop where a vehicle is being towed. There's police officers present. And at that time, he decides to park his car in the entrance of a neighborhood and get out and walk home from that area instead of turning around and driving an alternate route home or waiting patiently for the traffic stop to clear out, or even slowly driving around the traffic stop. And so with that kind of basis for going forward, I will address each of the legal issues in this case. So to begin with reasonable articulable suspicion, we have the deputy Wynn testify that he saw the defendant in physical control of his motor vehicle illegally parked at the entrance of a neighborhood, and the state has charged him with this underlying traffic offense relatedly. And the officer approaches the defendant who's walking down the road and begins to question him. And at that point, there is no necessarily tier 2. It's just a tier 1, conversation between the police and pedestrian at that point, even though he had just witnessed him park his vehicle and begin walking, illegally park his vehicle and then begin walking down the street. And the officer begins asking him exactly where he's coming from, what he's been doing that evening. And the Georgia Court of Appeals tells us that inconsistent statements by suspects prior to detention meets the threshold of reasonable articulable suspicion. So Mr. Duarte tells us that he is coming from Kroger, and then he changes his story that he's coming from Quick Trip, and then he tells us that he's been at multiple bars, that he had not been drinking, that he had been drinking. And so we have a lot of inconsistent statements by the defendant in this case before this truly escalates into a DUI investigation. And the threshold is even lower than that, Your Honor, for reasonable articulable suspicion to exist, even if the officer is mistaken, such as the Georgia Court of Appeals, Abercrombie v. State, 343, Georgia App 774. When an officer acts on good faith basis that an unlawful act has been committed, the officer's actions are not rendered improper by later determinations that no crime was committed. And so the state would contend that there is more than enough evidence in this case to satisfy the threshold of reasonable articulable suspicion to question Mr. Duarte, as well as escalate this to a tier 2, which would be the DUI investigation. Now, specifically, the probable cause for the arrest of DUI, we do have the odor of alcohol in this case, and the Georgia Court of Appeals tells us in Lee versus State, 188 Georgia App 406, that the odor of alcohol is one of the factors that can be taken into account under the totality of the circumstances to escalate a traffic stop to a DUI investigation. But we also understand that probable cause existed merely because the defendant admitted to drinking on the night of the incident within 3 hours, as under the DUI statute, that probable cause can exist from the defendant's admittance to drinking. And Hughes versus State, 296 Georgia 744, tells us the standard is whether a reasonable officer could, from the totality of the facts and circumstances, conclude the possibility of DUI and driving at the time of the incident. Probable cause is established even if reasonable officers could could draw mixed conclusions. And in this case, Officer Wynn came to the realization that Mr. Duarte had been operating his vehicle, had committed a traffic offense, and was providing the officer with inconsistent statements. And there was an odor of alcohol, and all of those things taken together and the totality of the circumstance give rise to probable cause for the arrest of DUI. So moving on to the issue of the refusal of the blood test, Your Honor. So the Supreme Court of Georgia has told us time and time again that the blood test is not an infringement on the right against self-incrimination because blood is not compelled, blood is taken. We are not requiring, the state does not require a defendant to voluntarily provide blood that would be self-incriminating. Blood is taken, is drawn by a licensed medical professional, and therefore it does not infringe upon a defendant's Fourth Amendment rights. And so I have a quote here from Awad, which is a case that Mr. Sullivan has already quoted to us, or cited. The state compares the urine test at issue here to other tests involving natural bodily substances, such as DNA or blood, which we have held do not implicate the right against compelled self-incrimination. Unlike a urine test that requires a defendant to intentionally produce urine in a particular manner suitable for chemical analysis, obtaining a DNA or blood sample generally does not require a defendant to affirmatively produce evidence against himself. And that's from the Georgia Supreme Court, Awad versus State, 313 GA 99. And so I think what we have here is Mr. Sullivan is trying to do the good work and challenge the laws of his state, which is respectable, but it is not to be done in the trial court, right? And so State versus Brannon, 267 GA 315 tells us properly enacted statutes carry a presumption of constitutional validity, and inquiry into the constitutionality of a statute generally should not be made by the trial courts. So the implied consent notice that was entered into evidence in this case that every police officer in this state carries in their pocket for the purposes of DUI investigations and arrests is codified into the official code of Georgia as 40-5-67.1. And as of today, as well as of the time of this arrest, is a valid law in the state of this, in the state of Georgia. And as such, it's our duty to follow that law. And as of today, blood test refusals have been deemed admissible against criminal defendants accused of DUI. And so in conclusion, Your Honor, the state contends that reasonable articulable suspicion existed for the stop of Mr. Duarte, there was probable cause for arrest, and the defendant's refusal to the blood test should be deemed admissible if this case were to go to trial. And we would ask you to deny the defendant's motion. Thank you.
All right. I'm gonna take the matter under advisement. I do intend to read each and every case that was cited today. I do that. I'm not gonna require a supplemental brief from either party. If you wish to submit one, that's fine. I am just gonna ask for a proposed order. And if your proposed order does not contain each of the cases cited, if you just give me a bullet point list of them and I will look them up myself because I do intend to read them in their entirety. All right? Is there anything additional from either state or defense? Before you go, I'd like to hear, what is the current offer on this file for the state? Is there an offer?
One moment, Judge.
All right. You know, I always ask that. It's all every time before we go. It's my hope that we can resolve these informally and come up with something reasonable.
Judge, I have it.
All right, what is the offer?
This was submitted by email by Ms. Githier on July 13th. that they were offering Mr. Duarte to plead guilty to DUI less safe, 12 months to serve 24 hours credit for time served, for 24 hours balance probated, $500 fine, 40 hours of community service, alcohol and drug evaluation, any recommended treatment, DUI school, and the victim impact panel remaining charges to be dismissed.
Is that the current offer, Ms. Waltrop?
Yes, Your Honor, that would be the last offer that would be.
And Ms. Sullivan, I'm assuming your client rejects that offer.
That's correct, Judge.
All right. Well, I hope the negotiations will continue. I look forward to receiving your proposed orders and briefs. Thank you.
Thank you, Judge.
You have a good afternoon. I believe that the one position we were waiting on is now present, the attorney. I think I saw him come on to Zoom. Is that correct? Let's see. Is the attorney for Miss Lauren Kennedy, 20 CR 002383E, currently on the line? Miss Kennedy is here in the courtroom. If you're on, you're muted. The number, I believe, 678. It begins with 678. Can you call your attorney?
I was just gonna say from the image I've seen on the TV, it looks like he's a.
Yeah, he is on here. He just can't hear us. Please send him a message and tell him to unmute his screen if you can.
You want me to step outside?
Yes, please. Thank you. Ms. Turner, do you have the ability to scan down there? Can you scan these to me?
Okay.
Thank you. Those are mine for civil.
I believe so. Thank you.
Thank you.
If it works, if it doesn't, don't worry about it. I didn't mean to give you additional tasks.
It's fine. I was. Doing some
You know, the judge of the prosecutor.
Yeah. Yeah, wait, let me make sure.
On the voicemail?
Yes, ma'am. But I brought my, like, I was supposed to bring my community service hours and stuff, so I brought my community service hours. And I didn't know if I was gonna have a chance to speak or anything, but.
Yeah, of course. Just 1 second.
Okay. You got it?
Is he?
Mr. Kane is disconnected from the Zoom. I think he maybe was trying to answer the phone call. And I think his connection also is not that great. He's at the airport right now. So I'll just wait for him to join back on the Zoom.
Okay.
And prosecutor Argento. Sorry. It's a jury trial, sir. Is that gonna process?
Well, that's fine. What day is it?
All right, can you hear us?
Good morning, Judge Daniel Kane. I can hear you now. Thank you.
Good morning. Are you aboard a flight? Can you hear us?
I'm with.
Mr. Kane, are you on a plane?
Well, I was on a plane when I connected, and now I'm coming up the escalator at the MARTA station at Carnegie Street and Peachtree, the longest escalator in the world. That was by far the longest motion to suppress on a DUI case I've ever experienced in 40
Not
years.
quite the longest one I've experienced. That was kind of good.
But I mean, on
All
that
right.
issue of implied consent and suppression, it was lengthy.
Did you
Learned it.
enjoy it? We're all gonna write a joint law review article when we finish. I enjoyed that.
You know,
I'm a little bit of a legal nerd, so I enjoyed the case.
yes, I'd like it. I'd like to read those cases to see who's on point.
All right, maybe you can help me read them afterwards. We can talk about it. All right, your client is here in the court, Mr. Kane. She's
And
here
I've got
for your clients. What was she supposed to do?
She's supposed to do community service, I believe 30 hours, and I understand she has about 25 done. So we're getting close to completion.
All right, so Miss Kennedy, you weren't able to finish your 30 hours? You can come up here, yes.
No, ma'am, but I can do them. I just at this point have 25 up until this date.
Okay, what happened where you couldn't finish your hours in time?
Just being transparent, I have worked 2 full-time jobs and it's just been incredibly difficult I'm a chef, and with it being the holiday season, my schedule has been very, very tight. However, I have tried to accommodate the court. And like I said, I don't have any issue going forward with my community service as I volunteer each month. I'm just being honest, I only have 25 to this date.
Do you have proof of the 25 today?
Yes, ma'am. My attorney has them in his email and I have them in mine. I just
Can I
need to.
see your proof?
Yes, ma'am. Can I pull it up on my phone?
All right, that's fine. We'll look at your phone.
Here you go. Thank you so much.
All right, what is my next compliance date? Ms. Turner? Does the state object to me resetting her one time to complete the 5 hours? All right, we're gonna allow you to continue, all right? Please get the 5 hours done. I'm about to find out what our next date is. Can you give me something late January if possible?
I'm sorry.
One second, I'm talking to Ms.
Oh,
Turner.
I'm sorry.
I'm trying to come up with a date to give you about 30 days, okay? To get
Okay.
the 5 hours. This will be your last reset. You must come in with the additional 5 hours after that, okay?
Yes, ma'am.
Okay. Okay, yeah, so. You can do it. We can just do it. Yeah. Is it totally full? What about a status is full too? All of it is full. Okay, we're gonna bless you. The holiday season is coming up. You have until March 1st, okay?
Thank you so much.
There should be no reason why 5 hours aren't done by then, okay?
I give you 15.
All right, sounds good, okay? We will see, Mr. Kane, your client's gonna come back on March 1st with proof of those hours, all right? Well, you can tell him what we said. He's frozen, but he knows.
Okay.
I'm sure he won't object to that. All right, I believe you're free to go at this time, Ms. Kennedy. Take care.
And I wanted to say something as well.
Sure.
I'm a person in long-term recovery now, and I don't know if I'm pretty sure you can see the history of this case. And I just wanted to say this was a challenge for me, but this has been it's actually been a blessing. My recovery, I'll have 5 years sober in May, and it's been a challenge, but it has been a blessing. So I appreciate the blessing you've given me to extend my hours and have a wonderful holiday season.
All right, you bless somebody else, okay? Take care. Bye-bye. All right.
All right,
Mr.
Judge,
Kane,
may I be excused?
yes, you may. Your client has until May 1st. I didn't know if you could hear me. I'm
I
sorry,
heard
March 1st, March 1st.
Yes, Judge, I heard you. Thank you.
All right, take care. You can be excused. And
Good
with
day.
that, I believe we completed the entire Orca compliance and motions calendar. Take care, everyone. And if I don't see you before then, have a great holiday.
It's your judge.
All right, bye-bye.